Hello, everybody. Thank you for joining us this afternoon for this interesting webinar of the Italian group of AIPPI, focusing on the protection of cultural heritage between exclusive rights, exception, public domain. We would like to focus on rules in Italy, in Germany, and in the European Union. That's the reason why we have such distinguished speakers today that I will introduce you later on. Now, just let me show you the housekeeping rules for us to manage the webinar today. As you are aware, we will carry on until, let's say, 6:30. We would like to have a short space for Q&A at the end. So we will try to wrap up our discussion around 6:15, but please let us have your questions in the Q&A box. I will monitor them and then propose the question to the speakers. As you are aware, the webinar will be recorded and we will try and have it available on AIPPI website as soon as possible. If you have any issue, please send a message in the chat box to AIPPI event. There is also a brief survey after the webinar that we would like you to fully fill in if possible, and thank you for your feedback. Now I introduce you to our distinguished speaker today. But first of all, let me introduce myself to you. I am Simona Lavagnini. I'm the president of the Italian AIPPI group, and I have the honor here to have Alessandro Cogo, Eleonora Rosati, and Bernd Nordemann. Speaking of this cultural heritage issues, Alessandro Cogo will moderate the event. He's an attorney in Italy and he's a professor at Turin University. Eleonora Rosati, she's also Italian from origin, but an attorney, but she's also a professor at the Stockholm University. And then we also have a German colleague, Bernd Nordemann. He's an attorney and he's also honorary professor at Humboldt University in Berlin. Now, I think that the floor is yours, Alessandro, to present the topic in more detail.
Thank you, Simona. Actually, my understanding was that you were up to present the topic, and so I am a little bit ashamed of what I'm going to say. Anyway, so the idea here is to discuss, this is at least my understanding, a stream of cases arising from the Italian courts, several courts in Italy, basically following the same path, and that is to say that after copyright law, copyright protection has expired on certain works of art, then if they belong to public institutions, then the said public institutions can prevent others from using the same cultural goods and the image, so reproductions of such goods, for profit, unless the party that wants to use them obtains an authorization from, say, public bodies, and then pays what is required by the law. This is happening under the Codice dei Beni Culturali, so the code protecting cultural goods in Italy. You might ask yourself, why are we discussing this in international forum? And the fact is that the Italian courts kept saying that such protection that is based on Italian law alone can apply also to use of, say, the images of cultural goods abroad. That's why we have here Bernd Nordemann from Germany, since there's a decision that he will explain in a bit, and saying that, well, this may not be the case, that Italian laws can be enforced somewhere else, even in the European Union. But having said that, I leave immediately the floor to Eleonora, who is going to present to you this stream of cases from Italian courts and highlighting the basic juridical problems that we are going to discuss this afternoon. Eleonora, please, the floor is yours.
Thank you, Alessandro, and thanks to AIPPI for the invitation. It is a pleasure to be here. And indeed, as you pointed out, this is a topic that when it first emerged in case law appeared a curious one, if you pass me the expression. But since the amount of cases has been growing and so has been the interpretative stance of Italian courts, this is a matter that is becoming increasingly relevant on an international scale, whether it is because of the territorial scope of application of this Italian law, questions of compatibility or lack thereof with the EU law, and also because Italy is by no means an isolated case. There are other countries in Europe that have approaches that are rather similar to the Italian one. Greece is an example. So what is the starting point? Indeed, the starting point is this cultural heritage code that remained relatively unapplied for quite some time, until indeed the first cases were brought by some of the most active museums in this sphere. Probably the record goes to Galleria dell'Accademia in Florence, which has filed a number of cases and also threatened litigation on a number of occasions. But the same is true for Galleria dell'Accademia in Venice, where the Vitruvian Man is held, and also the Uffizi Museum in Florence once again. So let me start by noting one thing, that indeed the relevant provisions are those contained in Article 107 and following of the Italian Code. But before going there, if you look at Article 2 and the notion that is given there of cultural heritage, the definition of cultural goods is a rather broad one, and indeed the law says that these are things that have an artistic, historical, archaeological, ethno-anthropological, archival, bibliographical interest. So far the focus has been indeed on what we classify as artworks, but I will note at the outset that the definition is not limited to those. So I see in the future also the possibility for extending the reach of this code to other objects that satisfy these requirements. So where do we stand right now? The most recent decision, if I'm not mistaken, is the one of the Bologna Court of Appeal in autumn 2023, which in essence concerned a vinegar bottle carrying the image of an artwork held in Modena. It is the portrait of Duca d'Este. And the Bologna Court of Appeal had a chance to indeed revisit a lot of arguments raised by defendants, litigants, and accepted or not by courts over time. So the starting point is the following. As you pointed out, that indeed if someone is planning a commercial use, and also here we can have a discussion as to what qualifies as commercial, of a cultural artifact that is held by an Italian public administration and satisfies the requirements that I recalled, then an authorization must be sought by the relevant administrative authority. And here already I would like to note one thing, that right now we have some guidelines regarding indeed the price of these licenses, but for quite some time this was not the case, and practice tells us that different Italian cultural institutions had different approaches on how to quantify the value of using indeed the goods held in their collections. Of course, permission is not required for each and every possible use. If the use is meant for the purpose of research, criticism, or review, no permission is indeed needed. So the effect of all this has been that Italian cultural institutions, for a number of reasons that I'm happy to detail, some are more cynical than others, have started noting when indeed the image of cultural goods in their collections were used without their permission. This has been the case in the context of advertising activities, editorials published in magazines, but also unlawful tickets to Florence museums carrying indeed the image of Michelangelo's David. And so in all these cases, there has been the rediscovery of these poorly written provisions of the Cultural Heritage Code and the bringing of actions against those using these images without permission. So as I said, the range of defendants has been quite varied. We go from vinegar producers to indeed printers of unlicensed tickets to museums, advertisers, magazines, editors, and also fashion designers. One such example was the threatened litigation against Galliano by the Uffizi Museum. So when a litigation has been brought in all these instances, the response of Italian courts has been uniform, I would say. This is a breach of the Cultural Heritage Code, and if that is a breach, there is no way for you to escape paying damages and indeed having to obtain a license if the use is to continue with the authorization of the competent authority. So there is no doubt about that. What is, however, more intriguing about this line of cases, which is overall very consistent, is in essence 3 points, I would say. The first one is the territorial scope of application. How far does this Italian law go? Is it limited to uses that take place in Italy, or can it apply also internationally? And this is something that was at the center of indeed the Ravensburger case concerning the use of the image of the Vitruvian Man by Leonardo in indeed a puzzle. This case has been litigated both in Italy and in Germany. We will hear about the German side imminently. Insofar as the Venice court is concerned, the view was that indeed this Italian code would apply also outside of the Italian border. The second point of interest is the argument of a presumed lack of compatibility of these rules with EU law. As you pointed out, Alessandro, these objects naturally are protected by copyright, and at some point, whether one likes it or not, the copyright comes to an end. Therefore, the question arises whether this code, as a matter of fact, introduces some sort of sui generis copyright that is disallowed by EU law, whether it is the term directive setting a certain duration of copyright, whether it is Article 14 of the DSM directive, which was introduced into Italian law without prejudice to the application of the Cultural Heritage Code, and was adopted at the EU level in response to the outcome of a high-profile German litigation. So we shall return on that. The third point that I think is important is the legal qualification of the right at the basis of this permission. What are we speaking about? Is it something that is purely administrative in nature, some sort of I will not use the term tax, but something of this sort that you need to pay to the Italian state in order to use the image of things held by Italian administration? Or are we speaking about some sort of substantive right enjoyed in these images? And the latter seems to be the characterization that Italian courts have been embracing. And this follows from a line of cases of the Italian Supreme Court, which has recognized the possibility for Italian image rights, which are rather protective, to be enjoyed not only by natural persons, but also legal persons, specifically companies. So something that is very different from country to country, and that in Italy is considered a personality right, is also something that can be enjoyed by subjects other than natural persons. So, since the Italian Supreme Court has said that image rights can be enjoyed by legal persons as well, Italian courts have adopted this interpretation to say that what we are speaking about when we are speaking about the provisions of the Italian Cultural Heritage Code is image rights in indeed these cultural artifacts. So here the thing is intriguing for several reasons. First of all, is it really a right that we are speaking of, and is it appropriate to extend it to something that is held in an object owned by someone other than the owner of this image, the artist who made it, etc. So I see many interesting ramifications and potentially many difficult problems that arise regarding this characterization. It has been embraced by the Florence Court, both at first instance and on appeal, and most recently also by the Bologna Court of Appeal, which has indeed considered this approach entirely appropriate to characterize what we are speaking of. So this is a brief overview of what I think are the unifying points that emerge from this line of cases that overall is pretty much consistent. Bottom line, for sure, if you want to use the image of a cultural heritage good in Italy for commercial reasons, you need really to seek a license. If you don't do that and litigation is brought against you, you are most likely going to be found liable for breaching these provisions of the law. Gray areas arise in relation to uses that are not commercial, what means non-commercial, and also uses that take place outside of the Italian territory.
Thank you, Eleonora. You said already a lot about the topic and you already prepared the stage for our discussion since you raised many of the relevant questions, but you just raised the questions and it's going to be our task this afternoon trying to address at least some of them. I think that we are ready to hear from Jan what was the view of the court in Germany, in Stuttgart, who had to decide whether this Italian code protecting cultural goods could apply also to German companies and regarding the commercialization of goods outside of Italy. I would like to hear that now because I think it is going to help us adding some details to the stage, to our discussion, and then helping us trying to address the questions that were raised already. So, Jan, please.
Yes, hello everybody. Thank you for the invitation, Simona and Alessandro. It's great to be at least digitally in Italy. Of course, it would be much better to be there in person, but otherwise we wouldn't have, probably the seminar wouldn't be so easily accessible. But great to be here and discuss this really interesting topic, I think. Alessandro already said that there's been an interesting decision from Germany on the Italian Cultural Heritage Code, and in particular on its territorial application. And I first wanted to start with showing what the case was about. And you may see here what the case was about. It is about a puzzle. And it's about, you may recognize it, it's the Vitruvian Man who is used here by the German puzzle maker Ravensburger, and they obtained no authorization for it. The case made it to the German court because the owners of the right that Eleonora addressed under the Italian Cultural Heritage Code requested a worldwide license from Ravensburger. They did not request only a license when, you know, they distributed this puzzle in Italy, but they requested a license worldwide, in particular also for distribution in Germany. As Eleonora has also mentioned, there was a preliminary injunction proceeding in Italy, which enjoined Ravensburger from distributing the puzzle with the image, not only in Italy, but also outside Italy, which includes Germany. That's when Ravensburger brought a negative declaratory action in front of a German court, District Court Stuttgart. So negative declaratory action means they were suing to get a confirmation from the German Stuttgart court that Ravensburger was free to distribute the puzzle in Germany. So the District Court Stuttgart, the Landgericht Stuttgart held that there was no extraterritorial application of the Italian Cultural Heritage Code in Germany. Such an extraterritorial application would be against the territoriality principle of international law, which says, according to the court, that every sovereign state, every sovereign country only has jurisdiction for its own territory, but not for the territory of other sovereign countries. So Italy had no jurisdiction to enact a law which would have effect also on German territory. What is also, I think, important to mention is that the Landgericht Stuttgart, the District Court Stuttgart, did leave the question open if the Italian Cultural Heritage Code should be inapplicable because it breaches EU law. So that was left open because they said it definitely does not have extraterritorial reach to Germany, so there is no effect of the law on Germany. And that, of course, was enough to confirm that Ravensburger was free to distribute the puzzle in Germany.
Thank you, Jan. I have a number of questions I would like to ask you to delve into the topic. One of them comes from the decision of the German court in Stuttgart. Looking at the decision, I noticed that the court relied upon a scholarship that pertains to the field of trademark law. So at some point, I see they mentioned the Feldserke on Markenrecht. This is, I think, interesting since it links to an issue that was discussed by the Court of Bologna, Court of Appeal of Bologna, a decision that Eleonora mentioned before. The defendant, in that case, raised the objection that the court who decided the case was not competent, has no jurisdiction on the case, because the case was an IP case, and therefore the decision had to be taken by an IP court. So, putting together these two inputs, my first question would be, are we talking about IP? At some point, Eleonora said this could be considered as a sui generis copyright, quasi-copyright, something like copyright, something falling within the field of IP. But if we look at decisions in Italy, we see an attempt, particularly by some courts, to distinguish this right, let's call it this way, from an IP right. Eleonora, what do you think?
But my view is that it is easy to see a parallel with copyright because, as I said, these things were or are still protected by copyright. So it's not that the protection of the Cultural Heritage Code arises if there is no longer copyright. Given the broad definition, things that are still in copyright can also qualify as cultural heritage assets. So it's not that they are mutually exclusive regimes. Personally, I I'm not convinced that here we're speaking about image rights, but let's put this aside. Certainly, we're not speaking about a para-copyright thing. It is something else. It is an authorization for the use of an image, but it's not about the creation of a new copyright that safeguards reproduction, distribution, etc. Here it is the permission to use the image in the first place. So I see it as something different. And I'm sure we can discuss it in greater detail later on. I know that there is plenty of commentators who hold the view that the Italian Cultural Heritage Code is contrary to EU law, and indeed Article 14 of the DSM Directive, Term Directive, to mention copyright-specific legislation. But the way I read it, I'm not persuaded that this line of arguments is correct. So in my view, we are not speaking about IP. We are not speaking certainly about copyright. We can have a discussion whether the characterization of these things as image rights is correct.
I see. I have a few things maybe to say on that, but I would like to hear Jan first. What's your impression, Jan?
So I'm, generally speaking, I'm with Eleonora. So what I think I can definitely say, this is not copyright, because copyright is something different. Copyright is for works that are created by human beings. There are moral rights linked to them. This is not what the Italian Cultural Heritage Code talks about. No moral rights in it. Well, it's not linked to, let's say, human creation, and that's why there are also no moral rights in it, etc. Excuse me. It could be that we are talking about a related right to copyright, but I also think that probably this categorization would not be correct, because related rights always have a certain connection to copyright. Yeah, and in my understanding, the Italian Cultural Heritage Code is very disconnected from a copyright. Yeah, as Eleonora said, it's an image right. I think probably a better description of the right, that it's an extension of the tangible property. That's how I would classify it. So it's not intellectual property, but it is something that is related to the tangible property in it. That's also my understanding of but maybe you can correct me if I'm wrong, the Italian Cultural Heritage Code also kind of links the right to tangible property. Yeah. So in my view, it would be an extension of the tangible property, and that probably already rules out a relevant conflict with EU IP directives. In particular with the term directive and copyright, because the term directive talks about works rights of an author, and certain 70 years after the death of the author, this is not what we are talking about here. It is not linked to an author, the right. So I think there's no clash with the term directive, and also no clash with Article 14 of the DSM directive. I would be same opinion here. Maybe you want me to go into further details here, but I will stop here for the moment.
Thank you, Jan. We are going to cover that, I think, later on. But it's good to have also these questions regarding impact of EU law on these provisions of the Italian code before us, so we can start thinking about them. I would like to indulge a little bit on the qualification of this right. At some point, Eleonora said that it comes from previous case law from the Supreme Court, the Italian Supreme Court, that relates to personality rights of legal entities. I think this is very interesting. This is very interesting. Why? Because the leading case that is also quoted by the decisions that we are discussing now is a decision from the Supreme Court that referred to a commercial exploitation of the image of a boat, a sailing boat, by a certain company that used that race sailing boat for commercial purposes. So put a trademark on the sails, even though in the original boat it was not that trademark, and use it to promote its own activities. And in this decision from the Supreme Court, you see the court saying, well, this could have been unfair competition, but there's no competition between the two entities, the plaintiff and the defendant, so we have to rely on something else. And so the court said, well, we could rely on general tort law. And why we can do it? We can do it because there are certain goods, such as in this case, the sailing boat, that are so much connected to a certain entity, a person, natural person, a legal entity, that you could consider the boat, the good, as part of the image of the legal entity or the natural person. And this is where the idea of the image protection comes in. So in a sense, it was an invention of the court to overcome the specific problem that unfair competition could not apply. But then it was something very new for Italian law. It was precisely the idea that you could protect also things related to a person as a projection of the image of the person itself. If you look at cases dealing with cultural goods, the cases we are discussing now, you see all the time courts saying, here we are protecting the image of a nation, a collective image that is somehow represented by the cultural goods that are being exploited commercially by someone else. So I'm stressing this because I think it is very helpful to understand what you said. We are talking about something that is not IP. And this is, I think, explained very, very well in the decisions. I'm not saying that they are right, but it is just to, to explain why we are pretty much convinced that we are outside the field of IP. I know that Simona has some questions regarding this legal construction. She has been discussing this with all of us several times. So, Simona, maybe you want to jump in and say what you think.
Yes, well, actually, I think that it is a very tricky assessment because there are a number of overlapping issues here. When I started studying the Cultural Heritage Code, my first understanding was that there was actually something in connection with the tangible good, as Ian properly said. And in my opinion, the idea was that since there are costs connected with keeping the good, whenever there is a reproduction, meaning that there is a photograph or a shooting, there is a physical connection with the good, and on the one hand implies that the good is in a way in presence in the shooting or in the photograph. On the other hand, it could be damaged. Then the entity keeping the good and managing the good could have a kind of reward to make sure that that there is enough protection, etc. But then, as Eleonora said, this has become something else entirely, which is grounded, as you said, in the image right of the public entity that recognizes itself in the heritage as the heritage good is a distinctive sign of the personality. As we see in Italian case law, for instance, we have artists where the glasses or the hats have been considered as a distinctive sign of the artist. This is more or less the same thing. But at the same time, what I really struggle with, and this is the reason why I think it is entirely outside of the IP system, and in my opinion, may be entirely outside of the system as such, is that this right has no end. So whenever we think of IP rights, on the one hand, we think of a reason for rewarding something, generally coming from a natural person, which is creativity in copyright, what is the invention in patent, etc. And the monopoly for a certain period of time is a kind of compromise between the interest of the public in acquiring the invention, the culture, the work of art, and the reward, the time for which the exclusive protection basically allows the author or the inventor or whatever to gain, to recoup the investment. In this case, there is no end time. So again, either we think this is one way or the other connected with the need to keep the good, with a tangible surviving, with the need to make the good survive, or I don't really see, in my opinion, especially to the extent where we have seen it used in the Ravensburger's case, because one thing is using the image of the good really as a distinctive sign. Another thing is probably using it in a puzzle or in other kind of exploitation, especially if we think of situation in which, and we come to the copyright here, there are reasons very similar to the so-called panorama Freiheit exception that Ian may extend upon later on. So I think that there is a tension here between opposite interests at stake, and I don't think that for the time being we have found the right compromise.
Thank you, Simona. I might say that there are certain fields of IP that we attorneys are not very much familiar with them, that do have similar traits. I'm talking about the protection of genetic resources. I'm talking about traditional cultural expressions, traditional knowledge and the like. I think we are closer to that field of IP than to the field of individual private rights. And in that realm, you also find cases in which communities do want to have a permission right and not just a remuneration right. At some point, Eleonora said, this is not tax. We're not talking about taxes. Yes, you might have to make payments. The payments might be aimed at helping the public institutions keeping the goods and making restorations and the like. But at the very end, there's this permission right, this exclusive right that is disturbing from that point of view, and that it's an exclusive right, as we could say, that you could justify only if you find something else, something more relevant, more pregnant, not pregnant, I'm sorry, this is not the right word in English, but more relevant for the community to protect just an economic interest. I would like to ask our colleagues about copyright. Jan said already something about the compatibility or incompatibility with copyright law, but Eleonora, and you also said I'm part of the minority who thinks who think that this might be compatible. Could you please elaborate a bit on that?
Sure. So before I do that, telegraphically, and then I will return on that. Speaking of pregnancies, it is a fact that cultural heritage institutions have been struggling over the past several years, and they've been trying to find ways to deliver money to and not just babies to support their own activities. And the ways to achieve that have been multiple. So Italy has come up with this cultural heritage code, and we are still discussing what it is. But if you think about the UK, I mean, before the Court of Justice, in essence, told them that originality requires creativity and it is not just skill, labor, or effort, all the websites of UK cultural heritage institutions put a copyright symbol next to digitized images. So in essence, if you wanted to use a digitized image, you need to obtain a license because this was claimed to be copyright protected. Germany, as I said, they had this related right protection that applied also seemingly to artworks and not just to simple photographs. And this was at the center of this high-profile case from which Article 14 derived. So here we are speaking about money, how to make money, and how to allow the cultural heritage institutions to conduct their own activities in an increasingly problematic framework where the support from states is going down, as it is the case of other cultural activities. So that is the first point. Now, coming to the question that you've raised, I don't really see how an argument could be made that this cultural heritage code is contrary to EU copyright rules. If we start from Article 14 of the DSM directive, it says that in essence, let me open the provision, member states shall provide that when the term of protection of a work of visual art has expired, any material resulting from an act of reproduction of that work is not subject to copyright or related rights unless, etc., etc., it is original. So what is here the original sin? That the Italians, when they transposed Article 14, felt the urge to say all this is without prejudice to the Italian Cultural Heritage Code. But frankly speaking, there is no need to say anything like that because the provision is not about this. First of all, the provision speaks about copyright and related rights, not any rights, one. And second is about claiming that this material resulting from an act of reproduction enjoys protection on its own. The Cultural Heritage Code is an entirely different mechanism. It's not about saying that the copy is protected. It's about saying that if you want to make a copy, you need to receive permission. So it operates on a completely different level at the outset. So I don't really see how in good faith one can make an argument that there is a breach of Article 14 and its constraints. A provision, by the way, that has been inserted very late in the legislative process leading up to the DSM directive, and it was upon impetus from some specific stakeholders in response to this German case. Second, the term directive is about the protection and duration of copyright, not other things. So here we are speaking about something else altogether. I'm aware that commentators have raised also the potential incompatibility with other EU legislation, but once again, my reading is that here we are speaking about things that are outside what has been harmonized at the EU level. So the real issue might be one of territorial application of these rules, but not whether EU law allows or prohibits them, because after all, we are speaking about an area of the law in which there is a shared competence between the EU and its member states. So what is not harmonized at the EU level is within the competence of national legislatures, and I don't see really how EU law prevents something like this code, despite its very poor formulation and the many questions that it raises.
Jan.
Alessandro, thank you. Yes, as I already said, I share Eleonora's view that Italy is free to do this without infringing EU law. In particular, Article 14 of the DSM directive is not infringed. I cannot add anything to what Eleonora said. Maybe I can add something to the term directive, because that is also an argument raised against the Italian law. It says, well, the argument goes, the term directive harmonizes the term of protection for copyrighted works to 70 years after the death of the author. So, and the Italian law is in conflict because it extends copyright protection, well, to without any kind of term of protection. I think that's not a good argument, because Article 1, that was Article 1 of the term directive, is about works of authors, yeah, and rights of authors. When do rights of authors terminate? Yeah, 70 years after the death of the author. That's also why the term of protection is linked to the death of the author, yeah, and not to any other incident. Yeah, and the Italian law, it has a different link. The Italian law does not link to an author. It links to, as we've already said, it links to tangible property, and that's a completely different link. And we are outside the scope of regulation of the copyright laws, and same is true for related rights, I think. What I want to mention, nevertheless, is one directive that may have a certain limiting effect, at least on the Italian Cultural Heritage Code, and that's the Open Data Directive. Very roughly speaking, the Open Data Directive obliges member states to have a law that allows reuses of public data by private companies. And this data may also be data documents from museums, for example. Yeah. But according to my understanding, not buildings, for example. Yeah, like the Colosseum in Rome or so, that is not caught by the Open Data Directive. It's about data. Yeah, it's not about buildings, for example. So, and also museums, for example, there's an exception from the rule that this data has to be provided for free to everybody who wants to reuse it, and that this exception applies to museums, for example, that are to a certain extent provide the data against remuneration. So, I don't want to say that it does not limit at all the Italian law, but at least there's a certain limiting effect for certain data that is caught probably by the Italian Cultural Heritage Code, and which must be then provided for free if it's not a museum, for example, if the cultural heritage institution does not qualify for a non-free license under the Open Data Directive. So the Open Data Directive is very complicated. I just wanted to highlight, we can now go into details, I think, but I just wanted to highlight that there may be certain limiting effect for the Italian law coming from the Open Data Directive and the Italian law that implements it, but not really 100%, or not anywhere near 100%, I think.
Thank you, Jan. Ladies, who would like to talk first? Eleonora.
But just a small note on what Jan has said regarding the term directive, no? So that directive harmonizes the duration, not of copyright to cure, of the rights harmonized at the EU level under copyright. So here we're speaking about economic rights. For example, moral rights are not harmonized.
Yeah.
And Italy, like some other member states, has a perpetual moral rights protection. So it's not that rights longer than life plus 70 do not exist already. Of course, here we're not speaking about a moral right, because as you, Alessandro, recalled, here the dignity that is protected is not that of Michelangelo or Leonardo, but it is of the Italian people and the nation, and etc., etc. So we are speaking about different interests, but indeed it's not that there are no longer rights than life plus 70 also within copyright law.
Thank you, Eleonora. Before giving the floor to my friend Simona, and also president of the Italian group, so I have to be careful with that, I would like just to add a detail regarding what Eleonora said. There is one decision among the bunch of Italian decisions relevant to this topic, in which the relevant institution said no to a certain use. It said, this use is detrimental to the image. We're not talking about money. We are talking about permission, dignity of the interest related to that. And it was the use of the Michelangelo for a certain cover on a review that was playing with this image. So I think this is useful because it helps understanding that there might be something in addition to just economic interest beyond this. I might say something more regarding this point later, after having left the word to Simona. Simona, please.
Well, thank you. Actually, I'm an intruder because I only had to introduce the panel, but I'm stepping in because my main focus here is to think of, I would say, general principles that are even behind not only copyright, AIPPI, I think the society as a whole, because even though I perfectly understand and agree with Eleonora and Jan and yourself, at the same time, I think that our system in general accepts exclusive rights, even moral rights without limitation, but at the same time has also sometimes of a limitation and balancing effect, which are in the exceptions. I know that you are thinking of speaking about this, but it strikes me that when thinking and studying about Article 14 of the Copyright Directive in the single market, actually the origin of the article was, in my opinion, entirely different from the outcome, because the origin was trying and thinking of a way to allow a certain kind of exploitation, especially of those kind of goods which are placed in public spaces, let's say something that everybody can see, and because they are not in a gallery or are at the crossroads. And again, there is a diverse situation here, but we see that there are some situations in which copyright as a limitation, for instance, for cultural reasons, information, etc. And I'm wondering whether this right arising out of the Cultural Heritage Code has exception, and if yes, which? Because certainly there is no provision in the code, setting aside what Eleonora said. And however, at the same time, if you think of image rights, then copyright, at least in Italy, still steps in, because we have an article in the copyright law explaining when the portrait of a person can be used. So I think there are indeed a number of overlapping situations in which maybe it's not copyright related, but there is some sort of clash, because if we use an image that is free under copyright, then we may be blocked by the Cultural Heritage Code. So
thank you, Simona, for adding additional layers of complexity to the topic. what I wanted to say before is that beside the idea of the qualification and the problem of qualification of this right and its relationship with copyright, we still have in front of us the problem whether the term of protection under copyright law, and particularly regarding the economic rights, because we know that moral rights, as Eleonora said, are not yet harmonized, even if there are people thinking the opposite. And I would like to mention here Professor Ubertazzi, who wrote a very complex article to demonstrate that they are covered by harmonization. But this is not relevant now. The fact is that the moral rights are not there to prevent any use on any base, on any ground. So if we have to speak about economic rights and the term of protection, the question is the term of protection under copyright law an expression of a principle that should be defended against any other law, preventing use of works that are in the public domain? We know that the question has been raised before in the field of IP. And at some point in our preliminary discussions, Eleonora raised the precedent, the decision of the EFTA court in the Vigeland case. So I was just wondering whether, Eleonora, you would like to say something in this regard.
But I mean, here we are entering the discussion of overlaps between different IP rights. And the truth of the matter is that there is nothing, at least in European law, that prevents these overlaps insofar as the relevant requirements for protection are fulfilled. Yes, in trademark law, there are these absolute grounds for technical shapes and other characteristics, substantial value, etc., etc. But it is not that if something was previously protected by an IP right, it cannot be registered as a trademark, or if it was protected as a trademark, cannot be protected also by a copyright or design, etc. And to this end, since we have a new Italian Advocate General at the Court of Justice, Biondi, I would like indeed to recall what he said in his first opinion delivered just a few weeks ago, Seram Tech. This is a referral from the French Supreme Court, asking indeed about how to treat something that was protected by an IP right before and is now filed for registration as a trademark. And he was adamant that this does not automatically disqualify protection. So I think that is indeed a correct reading of the law. As I see it, yes, the Vigeland case, the EFTA court took the position that this might be against public policy to register an artwork as a trademark. It might be a case of substantial value. And in that specific instance, the conclusion of the Norwegian IP office was that these trademarks should not be granted. But if we look at the registries, including the one of the UIPO, there is plenty of stuff that we would consider cultural heritage and is protected in one way or another through a trademark. So, truth of the matter is that in principle, this can be done. And the fact that copyright is time limited, as is the case of other IP rights, designs, patents, etc., does not mean that it is not possible to protect them otherwise, including IP itself.
I have something here for Jan. If you look at the decision of the Stuttgart court, it says there is no bis in idem in this case. The case is the same as the case decided by the Court of Venice. Since the Court of Venice decided on preliminary injunctions, there was no decision on the merit. We can adjudicate in Germany on the merit whether Ravensburger is infringing or not on this right arising from the Italian Code of Cultural Heritage. And you said rightly that the case was about non-infringement, basically.
No.
So the question is, if next time we have a decision on the merits issued by an Italian court saying that Ravensburger or anyone else using Italian cultural heritage abroad has to ask permission and pay, and there is an injunction or even a sentence to damages, would that be enforceable in Germany?
That is a very good question, Alessandro. It was an easy one for the Stuttgart court to say, well, it's not the identical case, just in a negative, mirroring, because the Italian case was a preliminary injunction case and our case is a merits case. So that's an easy one. That said, yeah, if the Ministry of Culture in Italy or the Cultural Heritage Institution brings a merits case, that definitely has the potential, at least, of avoiding, kind of legally speaking, avoiding claims in other jurisdictions if the claim is broad enough to cover it. And that's, of course, something you would then have to look into the EU law that regulates it, if still it is possible to sue in another state. Yeah. That is a very difficult issue, I think. But as a general rule, I think the arguments would get a lot better if the merits case was brought in Italy as well. That you could not go to court in Germany and file for a negative declaratory judgment on the same matter.
Thank you, Jan. This was an ambush, I know, but but it seems to be something about recognition of foreign judgments and objections that you could raise against the foreign judgments if they are against the public order. And that's why I thought it was connected with the Vigeland case and similar reasoning. I have a couple of issues that I want to raise at last. One of them is about fundamental rights. This is an issue that was discussed by the Italian courts. They say, okay, there might be a clash between fundamental rights, but at the end of the day, here we have something that prevails, and that is the idea of protecting culture. So Article 9 of the Italian Constitution. But we know that if we have something at the European Union level, so if we want to have, if we have a decision that has to be enforced in other EU countries, the question might be raised whether under the Fundamental Rights Charter of the European Union, this limitation to freedom under the Charter of Human Rights would be compatible, would be acceptable. What do you think?
But, as I see it, today there is no case that doesn't have a fundamental rights angle. So it is crucial indeed to think about this situation as well. So when we were speaking before about the limitations, as indeed also Simona recalled, it is not that you need permission for everything. Indeed, if it is also an artistic use, the permission is not required from the competent authority. So this is something that will make it compatible, for example, with Article 13 of the EU Charter, freedom of the arts, etc. But I'm seeing another potential fundamental rights angle that I'm throwing there as a provocation, no? So if it is true that this image right does exist to protect the dignity of the Italian nation, can we make an argument that this image right is protected under the right to dignity? I know that it is speaking specifically of human dignity, but the Italian nation is composed of humans. And therefore, this is something that cannot be territorially limited because this dignity is to be complied with also outside of the Italian territory. I'm putting it there as a provocation, but since the Italian courts have ventured into this potential minefield of issues, this is something that I think might also solve the territorial aspect that indeed Jan addressed from a procedural standpoint and make this right applicable outside of the Italian territory, which will not be unprecedented on a different level. Here I would like to recall the Facebook Austria case, in which indeed there was this politician bringing a case based on defamation concerning posts on Facebook concerning her, and she requested a worldwide removal of this post. And the Italian court, sorry, the Austrian court, in the end, granted this injunction. The Court of Justice, following a referral, admitted the possibility of worldwide removal based indeed on national laws, of course, subject to considerations of comity, respect of sovereignty, etc. But if we put ourselves into this dignitarian personality right angle, then I see that it is also possible to agree with the Venice court that this Italian code applies also outside of the Italian territory. Plus, a final note, there is plenty of situations in which the territoriality of rights has been watered down significantly, including in the IP field. How many times situations have been fictitiously located in a place that had nothing to do with the real place in order to root jurisdiction and so on. So it would be something that is not entirely unique. But again, I'm putting it there as a provocation.
Thank you, Eleonora. Jan, just a second, if I may. Eleonora said that there are limitations under the Italian Codice of the cultural goods. There is something interesting regarding that. You mentioned the limitation for freedom of expression, right? But in the code, it says that you can enjoy it as long as your aim is not for profit. This is strange because under copyright law, there is no such a limitation. And I think this might tilt the balance from the point of view of the balancing of fundamental rights. Sorry, Jan. Sorry, you can go.
I think this is a very important topic to balance even the commercial use, to balance it out with fundamental rights. Probably more if you apply it in Italy, in the Italian constitution than EU law, because usually the EU constitution applies more to EU law, to the interpretation of EU law, and I think we are not in EU law here. That said, what Simona has said, for example, if you compare it to copyright, it's a bit strange. In copyright, you have a panorama exception, that you are free to take photos or do paintings or other reproductions and use these reproductions as long as you are on a publicly accessible street. At least that's the way the German courts would interpret the panorama exception. So if you stand on a publicly accessible street and you take a photo of a copyrighted building, you're free to do that. That's an exception to copyright. If you take the Italian Cultural Heritage Code, if I understand it correctly, there's no such panorama exception. So interestingly enough, copyright law on the one hand, including EU copyright law, because the panorama exception is also in EU law, in the InfoSoc Directive of 2001 in Article 5. The Italian Cultural Heritage Code does not have this kind of exception, which and the copyright solution, the panorama exception, shows a certain weighing of interest, in particular also of constitutional interests, I think. Yeah. And so it is, at least I would say, at least when you look at the panorama exception, you could conclude that the Italian Cultural Heritage Code is kind of rather strict, and there is only a very limited weighing of constitutional interests involved. Yeah, if even copyright, which is a very respected right, you know, on the EU level and also on the Italian level, of course, and also on the German level, if they provide for such an exception and the Italian code, Cultural Heritage Code, does not, that maybe brings up certain constitutional issues, not because we're talking about the Italian Cultural Heritage Code as copyright, but because the code may be missing some important weighing of fundamental interests, yeah, here, and maybe it needs to be interpreted in a way that leaves more freedom in case, you know, you have an exceptional situation, like for example the panorama scenario, where maybe a free use should prevail.
Thank you, Jan. This is very relevant. The first case that we have in Italy regarding this issue is a decision from the Tribunale di Palermo, and it was about a picture of a theater from the outside. What is interesting is that after this decision saying basically that you have to ask permission and then pay if you get permission, film producers were very much concerned, because the idea was, what do we do if we have to record images of things around while we're filming? Do we have to ask permission all the time and pay? So there is no exception under copyright law, and the Code of Cultural Goods is adding complexity into that. I think that most of us say to the clients that they don't have to ask permissions. But still, this might be problematic somehow. This leads me to one of the concerns of Simona. Simona used to say that this right might be very impractical, very, very difficult to manage, since we have uncertainties about who is in charge of giving permission. We have uncertainties regarding how much you have to pay in individual cases, and so on and so forth, as also Eleonora mentioned at some point. But, you know, this is something that might be addressed as in an effort that might be just a fine-tuning effort at the end of the day. So I wouldn't second the opinion that because of these impracticalities you have to stop thinking about whether such protection might make sense. It might make sense, but still you might have to put in place some fine-tuning activity in order to make it work properly. Simona, our plan was at this point to take some of the questions that were raised in the chat. Honestly, I was not able to follow pace with the questions that were kind of elaborated also. So I'm asking you if you could help me at least starting the discussion.
Yes, of course.
Thank you.
Thank you. Thank you to the participants who have put in some questions. One is from Felix Hofer, and he says that in his opinion, the protection of cultural heritage is grounded in the Italian Constitution, and therefore he thinks that this would be the correct initial approach to the issue. What do you think about that? Because we do have Article 9 of our Constitution that protects, generally speaking, the arts and the culture. And this is in fact referred to in some of the decisions that you have been discussing so far as the base for the protection.
But as I see it, it is not an incorrect characterization if one has to indeed find foot in the Italian Constitution that would be the correct one to rely upon. Whether from these descends the possibility to again envisage a right over the image, I don't know if that is a stretch, but the starting point seems to be correct from how I see it.
If I may add something in relation to that, I think that here there is a bit of confusion possibly on the different grounds of protection, because I'm not sure that Article 9 of the Italian Constitution protecting the art and cultures would extend to the protection of the image of the cultural good as such. And I'm also wondering, since the broad definition of cultural heritage under the code would encompass anything from the Colosseum to even a smaller piece of art or anything else, I'm wondering whether this actually is a different thing. So there is one protection, the Cultural Heritage Code, which by rule of law should be extended to all these goods. And there is another protection, but it's different, which is or may be connected to some of these cultural goods, those who are so widely known, so closely embedded into a certain specific region, whereby those community really is identified by a specific image of this specific good. But would this actually apply to all the goods included and listed within the Code of Cultural Heritage? This is my question. I will then go through the other ones, but forgive me, I think this is an important point. Maybe Eleonora or even Ian or Alessandro.
I would add
none of us.
But you know, to your question, I would add another one that we have not discussed this evening. But you remember that in the past there have been indeed some very expensive refurbishment activities of some of the Italian landmarks, ranging from the Colosseum to the Spanish Steps in Rome, no? And by reading the relevant news reports, it seems that in exchange for private financing of these refurbishment activities, the municipality of Rome would grant an exclusive right to use the image, for example, of the Colosseum in advertising. So this is a right, a reason in contract, but once again, I've often wondered how it relates to the Italian Cultural Heritage Code if we are speaking about an additional mutation of the kind of situation we're dealing with. So going back to what you were saying, yes, the Constitution, image right, I would say that there is plenty of layers which are not perfectly in parallel with each other, and when they intertwine, they do that in a way that raises more questions than answers.
Yes, if I may say something on this, remember that the constitutional relevant provision that were invoked in this case was not just Article 9, but also Article 2, so the protection of human person or personality stemming from that. The hint, the idea of the question, I might add myself, is whether also constitutional law could somehow limit not just the protection, maybe the protection, but also the way in which public institutions can exercise this permission right. So the provision in the Constitution that you select as a potential ground supporting these provisions of the code might have an impact also on the freedom that public institutions have. Eleonora said an exclusive right to use the Colosseum. I believe this should be justified somehow. And here I stop.
Okay. I don't know whether Jan wants to add something to this, because we have plenty of questions.
Let's carry on with the questions, because the Italian constitution, I would not dare to comment, I think.
Okay, the following question from Heidi Hazem is, are fashion items, local historical clothes, included in the Italian heritage considered part of this legislation? And I would say it may be.
Potentially, yes, because the definition is so loose that pretty much anything that has some sort of interest qualifies.
Yes.
I have a question myself related to that. In the relevant decisions, you see that some of the defendants said, look, these provisions are unconstitutional because they discriminate public collections and private collections, because the right only arises upon public collections of cultural goods. Is this right? Does it make sense? Does it contribute anyhow to our reasoning?
Well, I think that it's one of the point where we see that our reasoning clashes, because if we want to protect art and culture, and if we want to protect on other grounds right of personality, then I don't see why only public entity should be entitled to that. Because it's not really, at least in my point of view, necessarily connected with this ownership.
On the other hand, you could say that if something gets into a public collection, it is because it is considered to be worth representing somehow the heritage of the relevant country. But this is probably arbitrary. So, because we know that there are other reasons behind the acquisitions of goods by collectors, even public collectors. So,
I have now a question for Jan in relation to the unfair competition issue. He says that Italian authorities could try to enforce the protection of cultural goods outside of Italy, not only on the grounds that we have seen, but also on unfair competition. The competition exists because the image rights are being granted by the right holders, and can be argued that who uses the Vitruvian man on this product makes a misleading statement about its relationship to the Italian museum, cities, and other right holders. It's misleading and passing off, like putting the Italian flag on a Swiss or German-made pasta. The Italian law on protection of cultural goods is part of public and national law, which is separate from copyright as private law and can stand beside it. And we have to thank Reinhard Hotley for this question. Ian?
Yeah, that's a good question, Reinhard. And I think it brings us to the core of the extraterritoriality problem. So what law do you apply outside Italy? As I said, the Stuttgart court said, no way you can apply this Italian law to German territory, because it's just, Germany is a sovereign state and Germany decides its own laws. So probably the rule is the country of protection rule that we know from IP law, is so you apply the law where you want your protection. So if you want protection as, I don't know, the Venice institution of the Ravensburger image on the puzzle, you have to use German tort law or unfair competition law as a specific tort law, for example. And if the use of the image of the Vitruvian man is unfair competition under German law. You know, you could sue for a breach of unfair competition law. I can tell you maybe the solution in German law, maybe that's also something just 1 minute I will spend on it, because of course, you know, Germany also has these cultural heritage institutions that always need money to preserve their cultural heritage. You know, same interests, but the solution is a bit different. It's kind of close to the panorama exception in copyright law, because the German tort law says if you take photos from a cultural heritage, you know, from a cultural heritage like a building or something else, and you do this from the property of the cultural heritage institution, they need to give you permission for this. And if you do it from a publicly accessible street, you're free to take the photo. Yeah, there's no image right. And so the Italian cultural heritage institutions could invoke this German kind of concept if the Vitruvian Man photo was taken, you know, is taken from, you know, if the photo was taken from property of the Venetian cultural heritage institution, they can sue under German law for tort, yeah, because the picture was a tortious action. Yeah, so but it's the country of protection that decides this question. It cannot be Italy who kind of, you know, passes a law that with extraterritorial effect, I think.
Okay, one last question, because we only have 3 minutes and we have then to thank everybody and say goodbye. I think that building and following up on what the last question was, the last question says, which is the limit? Is making a drawing of the Colosseum and putting it on a shirt a reproduction? Art has been working based on inspiration for centuries, and there are copies of this everywhere. And I would add to this that the Ravensburger case was actually, as Ian showed, the puzzle of the Vitruvian Man. It wasn't actually a use, it was kind of artistic use, question mark. And then, I mean, every one of you can answer.
But my contribution would be limited to the following. If now what we're speaking of are image rights, then in Italy they're interpreted quite broadly. And for example, there is case law that has found image rights enforceable even in case of mere evocation. There is a famous case concerning a model dressed up like the character of oligolyte Audrey Hepburn in Breakfast at Tiffany. So not the image of Audrey Hepburn was used, but a model dressed up like her. And the estate of Audrey Hepburn successfully sued because this evocation was actionable. So in the example that you, Simona, read, even if it is a non-verbatim reproduction, but something that evokes indeed a cultural asset, then potentially it falls within the scope of protection.
Same with the video games. Eleonora, I thought you were about to mention the Lucio Dalla case, but it is just because I'm older than you. Jan. These funny Italians. Before this seminar, I sent to Jan a decision from the Italian Supreme Court that said you apply also unfair competition law extraterritorially.
Yeah. Yeah, it's I think, I mean, to maybe summarize it from my part, you know, I have certain doubts about the extraterritorial application, but I have no doubts, no real doubts that the Italians were in line with EU law when passing it. Yeah, as long as it is restricted to the Italian territory. Yeah, I think that's just from the property right that you can do these kind of things.
Well, I think that we have more or less reached the planned end of our extremely interesting webinar. I have to really thank Ian, Alessandro, and Eleonora. I hope you can see the thank you slide, which you see is promoting the next AIPPI webinar as well as the AIPPI World Congress. We have opened this webinar even to non-AIPPI members because there was a lot of interest. And I'm taking this last time to promote AIPPI and the participation to AIPPI. So if you found this webinar interesting, take a look to the website and maybe you can enter into the local groups like the Italian group. Thank you again. And thank you for the participation.
Thank you very much.
Thank you.
Thank you. Bye-bye.
Thank you. Bye.
Bye.
Okay.